Okay, so for Consumer Protection Act, right, Unit 5, there is one concept called product liability. Okay, so it is from chapter 6 of the legislation, and there are few sections that we have. It talks about product liability. Okay, product, when we say product, right, under Consumer Protection Act, we have studied that it not just applies for goods, but also services. If you are taking some service like hiring a bike, repairing a fan, right, you will do something, all those are services that you are taking. So services are also included, goods are also included. When we say consumer, you may be a consumer of goods or services. Likewise, when we say product, it may include product or goods, the finished products that we use as a consumer, plus it may also include some services that we take. Okay, if you are taking some service and you are not satisfied with the service, you suffer some loss because of it, then also liability may arise. Okay, so when we say product liability, it may include liability arising because of any defect, maybe it was not up to the standard, or any issues with the product, which may include goods plus services. Okay, so chapter 6 is making detailed provisions relating to product liability. And these provisions were initially not specifically mentioned under the earlier legislation, but in 2019, there was a major change, right? We had Consumer Protection Act 2019. So this 2019 Act makes this chapter. It talks about this specific provision. Detailed provisions are given talking about product liability. So under this new legislation, Consumer Protection Act or CPA 2019, we have this specifically dedicated chapter, chapter 6, talking about product liability, where we get few sections, that is sections 82 to 87. Okay, so you need to remember the sections plus the chapter plus the thing that it's a new concept which is being specifically given, so that consumers can ask for this right. They can make the manufacturer, the seller, the service provider liable for any sort of defect in the product. Okay, so this 2019 legislation, you can also remember these dates as well. Okay, it was passed by Parliament on 6th of August 2019. It received President's assent 3 days later on August 9, 2019. And finally, it came into effect from July 20th of July. Okay, next year it came into effect. It took few months of time. So you can also remember these dates, because there will for sure be 1 or 2 questions from CPA. They may either ask you relating to the redressal forums. They may ask you to write features of CPA. So you can remember these dates, and whatever the question might be, you can fit in this information in your introduction part. All right, so this information is going to be relevant for you. You can remember it. Now, when we say product liability under CPA 2019, sections are 82 to 87 appearing in chapter 6 of CPA, and it provides for all the things that we need to know. When we say product liability, it's not just one person making a product. There are so many people involved, so much of process involved. So whom do you make liable? How can we make a person liable? All those detailed provisions are mentioned under these sections. So product liability is also being defined as the responsibility of a product manufacturer. You cannot simply make something and just keep that open for the public to use. You need to ensure it's safe for people to use also. So when we say product liability, it includes the responsibility. And if you are failing to fulfill your responsibility, you will accordingly be held liable. So it is responsibility of a product manufacturer, product seller, or any product or service to compensate for any harm caused to the consumer by such defective product manufactured or sold or by deficiency in service related thereto. You might have come across this, that there will be series of tests being done before a product is finally released and made open for public, right? If take for example, I have designed an AC, I would simply not just make it in one night and then keep it open for public. What I would do rather is I would try it out for maybe few days, few samples I would try, just to ensure that my design is safe and proper, right? Because there is electricity involved. If I simply just design an AC, make it out open for public, it might be risky. It may cause some loss or some damage to the public. And if I fail to take that step, I will be held liable. Okay, so it not just includes manufacturer, but in certain cases, it may even include a seller, because seller would also sometimes do some sort of tampering with the things. Okay, they would not sell it as they are getting it. They might do some sort of labeling, some sort of warranty, guarantee they may provide. In such cases, seller also may be held liable. It may be relating to any product or services that is being provided to a person. In case the consumer is suffering some harm or loss, the person can claim for compensation. Where and all you can make a manufacturer liable, where and all you can make a seller liable, all those provisions are being mentioned under these sections as well, 82 to 87. So product liability action you can file against product manufacturer, the service provider, the seller, whatever the case might be. Whoever was negligent on their part, you can accordingly file a case. CPA defines each of these expressions. So it clearly mentions who is a product manufacturer, service provider, seller, what are their liabilities, in which all cases you can file a case against whom. Everything is given under the legislation. So under these headings, right, we will be seeing where you can make all these three groups of persons liable. Okay, is this intro part clear? You can just reply on chat. Again, unmute problem, right? You can reply here. Is this intro part clear? Okay. So this thing you need to remember, because you need to anyways write an intro. Here you can fit in these details. Now, liability of product manufacturer, where and all in which all situations you can make the manufacturer liable. So first of all, product contains manufacturing defect. While manufacturing the product, there was some defect and manufacturer failed to identify it and fix it. As a result, consumer had to suffer loss, so he can file a case against the manufacturer. Or defective in design. Like I told you, I cannot simply design an AC and sell it out to the public. I need to test it, try it, that it is working efficiently. It's not risky for people to use it. Those things I would need to do. So defective in design might be deviation from manufacturing specification. Whatever specifications I have mentioned, whatever details I have mentioned relating to the product, it is deviating from those specifications. In such cases also, I may be held liable as a manufacturer. Product does not conform to express warranty. I have given some warranty, and later on when consumers came to claim for it, I simply refused that. No, this warranty is not applicable. I'm not repairing this. I'm not changing the item. In such cases also, case can be filed against me, because I was the one who had given express warranty. When you buy something, you would see, right, 5 years extended, 2 years warranty, 5 years extended warranty. By paying few hundred or thousand rupees, you can extend the warranty for 5 years. So after a consumer does that, takes that extended warranty, if I am not fulfilling my part, accordingly, case can be filed against me under product liability. I am liable for whatever commitment I have made. Again, product fails to contain adequate instruction of correct usage to prevent harm or any warning regarding improper or incorrect usage. whatever product you see, you will always get some warning messages, some safety instructions, how you need to operate in and all that stuff, right? So if I fail to mention those things, there also I may be held liable. Like take for example, I recently noticed that if you order some like edible items, right, some edible seeds and all, okay, when you buy those, right, it comes with some packet to, you know, like help it from oxidize. Okay, if it gets oxidized, it would get damaged. So in order to prevent that, they would give some packet of it. You should not consume it. So someone might consume it because it came along with this edible pack of seeds. So in that packet, right, small packet, they would clearly write, do not consume it, do not consume it, do not consume it. Entire packet, everywhere it's written. That means they have given some safety instructions. If you see at your house only your pressure cooker, there also some safety instructions would be written. If you see your washing machine, there also some safety instructions will be written. If you see some rice cooker, some safety instructions. Whatever item you pick, some safety instructions would be there. Even you can simply pick your t-shirt. There also backside you would see a label that would mention washing machine safe or only dry clean. They would even mention for a clothing, just a piece of clothing, how you need to wash it. Every single item comes with their own instructions. Why? Because otherwise it may cause loss or damage. Okay, something might be like very obvious, like every one of us have used a pressure cooker, but even then it needs to be mentioned. What if someone is using it for the first time? They need to refer to those safety instructions. So if safety instructions are missing and the loss is suffered, case can be filed against the person. Okay, so these are manufacturer against manufacturer where we can do. Second one is product seller. Where and all can we file a case against the seller also? Under this head, product liability. If he has exercised substantial control over designing, testing, manufacturing, packaging, or labeling of the product that caused harm. Sometimes you would see that the seller is taking an active part in what is being produced. Okay, take for example some local furniture, this shops would be there, right? If you go there, it might be one person who is selling those items, but he is not actually making those furniture. He is getting those made from some other local carpenter. Okay, so he might go there, give proper instructions that this is how you need to construct a chair, a table, a bed, whatever. Now, if some defects in the design that he had given, in the specifications that he had given, as a result, consumer suffered harm. In such cases, we can make the seller also liable, because seller is playing an active part in designing, testing, manufacturing, packaging, labeling the product. Might be he failed to put those safety instructions while labeling the item. It can be a lot of different things, right? So in such cases, we can file a case against seller as well. Or seller has altered or modified the product. Okay, seller has altered or modified the product, and such alteration or modification was substantial factor in causing the harm. Just because seller had altered or modified the design or the product, because of that only loss took place. In such cases also, we can file a case against the seller, because he was the one doing all the changes. Or seller has made an express warranty of a product independent of any express warranty made by manufacturer. Manufacturer might be given 2 years of warranty. In addition to that, seller also committed, I am giving you 2 years more extended warranty, 3 years warranty. So for this remaining 2 or 3 years, we can file a case against seller if later on he refuses to fulfill our claims. Okay, so when seller has given some independent or express warranty apart from what is given by manufacturer, we can bring the seller liable. The product has been sold by him and the identity of product manufacturer or of such product is not known. Seller we know, but who is manufacturer, from where it came, what is the process of warranty, nothing is clear. In such cases also, we don't have any other option. We just know the seller. So we can make the seller liable. Or he failed to exercise reasonable care in assembling, inspecting, maintaining such product. He would get it in some different pieces or different parts might be. He need to take little more care in order to assemble those, collect those and stuff like that. Okay, if you are buying some, might be you are buying a vacuum cleaner. It comes with a lot of different parts that we need to attach and then clean the house. If seller was liable that he failed to collect those 2-3 items which were like some safety items, in such case also we can help the seller liable. So basically, in cases wherein seller has failed from his part, we can make him also liable along with manufacturer or might be independently also. Okay, is this part clear? Manufacturer and seller's liability, where it will arise. Is it clear? Any point you want to be repeated? So next one is liability of product service provider. So product service provider may also be held liable, where the service provider by him was faulty in quality. Service provided by him was faulty in quality, nature or manner of performance. Like you would give your vehicles, your AC, your, might be this kitchen chimney, all those stuff for servicing. Okay, so while servicing those items, they might tell you, okay, fine, these 2-3 small parts of it you need to change, you need to replace. While you are replacing it, at that time, if this service provider is inserting some faulty items, something which is like below standard, some local parts they are installing, in such cases, we can even hold the product service provider liable. There was an act of omission or commission or negligence of or conscious withholding of any information which should cause harm. While he is doing the servicing, getting those small parts repaired, he failed to inform that, okay, fine, might be while changing the while changing some items in that, he failed to inform that this is how you need to operate. Okay, because I have changed these items, now might be you need to turn it off, turn it on, whatever it is, right? Some safety instructions might be he had to give. He failed to give those instructions. In such cases also, we can say that this person is liable who was getting the servicing done. Service provider did not issue adequate instructions or warning to prevent any harm. Whatever he should have told the person, he failed to tell that. In such cases, accordingly, loss is being caused, he can be held liable. Service did not conform to express warranty or terms or conditions of the contract. While providing service also, they will be giving some warranty or guarantee, right? They might tell you, okay, this vehicle is going to function smoothly for the next 2 years. But next moment when you are about to come back home, it gets damaged, some losses caused. In such a case also, we can hold this service provider liable that whatever commitments you had made, you are not basically fulfilling those. Those are not up to the mark, whatever you promised. Right? So in such cases, we can also say that product service provider is liable and we can file a case against him. Okay, then we have some exceptions which are also there under Consumer Protection Act 2019. The product was misused, altered, modified at the time of harm. If I bought a product, but because I was so curious to know, like this children would do, right? They would just open everything, every electronic item, they would just open and they want to see what is inside, how is it functioning. Okay, so if I am just opening something. Okay, I bought an AC, and then I just decided to open everything, just, you know, like segregate all the different parts, and then I turned on the switch. After that, something happens. In such a case, it acts like an exception. I cannot again say that the manufacturer or the service provider or the seller is liable. Why? Because I should not be doing something when I don't have that knowledge. I should not be opening the AC apart and then trying to switch it on. Okay, so in such cases, if because of me opening it and segregating the different parts, loss is being caused, I will not be allowed to file a case against all those people. It's my responsibility, it's my negligence. Okay, that's the first exception which we have. Secondly, in any product liability action, based on failure to provide adequate warnings or instructions, the product manufacturer will not be liable if, okay, even if I have failed to provide this warning or safety instructions, as a manufacturer, I may not be liable when the product was purchased by an employer for use at workplace and the product manufacturer had provided warnings or instructions to the employer. So these companies would be having contracts with different companies. It's like B2B, business to business contract. Okay, and they might say that in bulk we are buying something. All right, so there might be, these are because like specifically made for this company. Each of those items may not come with instructions, but one clear complete instruction is given to the company. Might be there was a special session on the safety instructions. So in such cases, just because one employer was not aware of those safety instructions or the meeting, that employer cannot file a case against the company because it was like a B2B contract, business to business contract. They had already mentioned all the safety instructions and everything clearly. All right, so that's the first ground, that even if you have failed to mention the safety instructions, you might not be held liable if you have already clearly mentioned it to the company where you are giving the products. The product was sold as component or material to be used in another product, and necessary warning and instructions were given by product manufacturer to the purchaser of such component or material, but the harm was caused by the caused to the complainant by use of end product, which was component. Like in case of mobile phones or laptops, all the different parts, if you see, would come from different areas, right? Like we see sometimes on our phones, I guess, that assembled in India. So we might see, okay, I guess in laptop, we would see, our mobile phones also, we will see assembled in India, but parts are coming from China. That means they are taking these different parts, might be camera, speaker, this, that, everything they are bringing, and then they are finally assembling everything and making a phone. Okay, so when they were bringing those different parts from China, for all those specific parts from China, they received clear instruction. But for this end product, the mobile phone, safety instructions cannot be provided by the manufacturer, right? Because China was just exporting those speakers or those camera or whatever it is. So in such cases also, person cannot be held liable because he was selling only those components or some specific materials. End product is made by someone else. Thirdly, the product ought to have been used only by or under supervision of an expert. It's not something that you can simply use yourself. It's so risky, or it involves some skill. It might be like a very heavy machinery that is operated in a factory for one day for some specific purpose or something. So there you need to use it under supervision of an expert, and you failed to do it. You just wanted to experiment with it yourself. In such cases, you cannot make the manufacturer liable. The complainant, while using the product, was under influence of alcohol. Whoever was using it, that person was drunk, that person was not in a mental state to read the safety instructions and to follow it. because of his fault only the loss took place. In such cases also it will be an exception, there will be a defense. And thirdly, the product manufacturer will not be liable for failure to instruct or warn about danger, which is obvious or commonly known to the use of such products. Some things are like very obvious or common, right? Like if there is this electric socket is there, we all know that we cannot just put our fingers inside it and then switch it on. Obviously we would get an electric shock. Something is very obvious, so obviously they would not tell you that okay, you do not put your fingers inside and then switch it on, right? So some things are very obvious. In those cases definitely they would not be held liable if you are doing the opposite. Right, take for example, some things are very common, like when you might be using a juicer grinder, you cannot just pour a bucket of water there. It's very obvious because it's an electronic item. If you are doing it, you would be held liable, right? And there was some Hindi serial was there where there was one there was a couple who got married. After marriage, what wife did is she was not aware of anything. Okay, basically what she did is she took her husband's laptop and washed it in surf excel, okay, in detergent she washed it, and then she allowed it to dry, right? So in such cases those are very obvious. Obviously your laptop would not come with an instruction that do not soak it in detergent and then wash it. That is something very obvious. Those instructions would not come, right? So that is the third exception which we have. So even prior to this also might be these grounds were used, but now by 2019 Act, these points are made very clear under the legislation itself. Accordingly, parties can claim for an exception or a defense under the legislation. And then finally, you can mention a conclusion that introduction of product liability, this is like a very welcoming step, because it will make the seller also conscious or concerned about what he is selling. Manufacturer also concerned about what is the product that they are giving to the customers. It's not just that customer need to be very much concerned or conscious about what they are buying, but rather the seller is also having some sort of liability. Okay, so accordingly, under these new provisions, we can make all these persons liable whenever there is fault from their end. All right, so this thing you can go through this part and read it also. These are some common things that we see in our day-to-day lives also, right? It's easy to relate to these provisions, Consumer Protection Act. So is this part clear? Any doubts you have?